SRIRAM's IS, serving the nation since 1985. Ab offline, hoya online, we are the lifeline.
Hello student, welcome to SRIRAM's IS. Welcome to this current affair class. This is class number 20. I am Mayank Bharadwaj presenting you this class. For your upcoming prelims examination, this current affair is going to be of great use. So another Supreme Court ruling has came, and this time the point in question is the intellectual property rights IPR, and it has a great combination with the SC/ST Atrocities Act of 1989. So we are going to see how IPR is linked with the SC/ST Atrocities Act. Now try to understand something which is very basic and very logical. This act, SC/ST Act of 1989, was made to protect the SC and ST community from all kind of atrocities, historical atrocities which has been there on these communities. To eliminate that, this has been implemented in order to implement the Article 17 of the Constitution, which abolishes untouchability in any form, and any kind of discriminatory practice in any facet which these communities are facing needs to be eradicated and abolished from this country. So this act works on that particular principle of elimination of such discriminatory practice towards the community, and at the same time there are prescription of punishments for people who are involved in these crimes, who are preaching these crimes, and also who are practicing these crimes. And at the same time there are also compensations provided by the state for any damages or for any loss to the property. I hope you have understood this much. Damages for any loss of property. Okay, so there are punishments prescribed. The state has to take action on those atrocities which are taking place, the discrimination which is taking place, and at the same time the damages to the property, if it is done, compensation will be provided. Compensation will be provided for damages to property. Now, important thing to understand is, what is this property here? What is the property when I say damages or loss to the property and compensation is provided for the loss of property or damages to the property? What does property means? Now, property can be physical property such as house, movable, immovable property. Immovable would be house, movable would be your bike, your car. If let's say because of any discriminatory practice, several people of a particular community burns down the bike or a car of a person belonging to SC/ST community, and that was done against the person of SC/ST community because of his caste. Now that is a discriminatory practice which is abolished, and that is punishable offense under this act. And if any damage is done, then there is a provision of compensation also. So if a bike is burnt or if a car is burnt, the state is going to provide the compensation to the person of SC/ST community. So the property simply means physical property or tangible property which can be touched. Movable, immovable, it can be of many types. But what about intangible property? What about intellectual property? IPR. Okay. What about intellectual property? Intangible. It cannot be touched. Is it covered under the word property or not? That is the question which was raised recently in front of the Mumbai High Court, who has ruled in favor of the petitioner, saying that the word property also includes intellectual property, because the word property covers into it the tangible and the intangible property, and the intangible property covers the intellectual property as well. So there were two Dalit scholars who were living in Mumbai, and they had some kind of a fight with the landowner, the house owner, and the son of that house owner has burned down their decades of research. Now that is a loss to the intellectual property, and a petition has been filed saying that compensation needs to be provided on the damage or loss to the property under section 15 of the SC/ST Act of 1989. So the question which came up was whether intangible property or the intellectual property is included in the word property under section 15 of this act or not, and the ruling was in favor of the SC/ST community, was in favor of the petitioners. So this is the whole issue in a nutshell. Now let us see what is there in the slides. So this was the this particular case was first filed in the Bombay High Court, which has then reached the Supreme Court, and Supreme Court has upheld this particular judgment of the Bombay High Court. So Principal Secretary of Government of Maharashtra versus Shipra Kamlesh of 2012. This is the judgment. So ruling was intellectual property including digital data is covered under the SC/ST Act of 1989. SC/ST Act of 1989 protects the marginalized communities. There are criminal and civil remedies which are given in it. There are non-bailable offences under this act. If you commit a crime, that can be called as non-bailable under this act. So there are few provisions which are provided for the protection of the marginalized community in the SC/ST Act. Okay, and section 15A, this is the section in question. Compensation for the loss or the damage of property. Now this property includes the intellectual property after the interpretation made by the Bombay High Court and then the Supreme Court. I hope you have understood this important issue. Background is two Dalit scholars lost decades of research on their laptop burnt by the landlord's son, and hence the petition was filed. The Bombay High Court ruled in favor and the Supreme Court has upheld that particular judgment. So the petitioners, who were the scholars, said that there has to be a broad interpretation of the word damage to property under Rule 12 of this Atrocities Act. This is rule number 12. The same or a similar thing is also written in section 15 of this Act, 15A. Intellectual property includes digital electronic materials and should be covered under the Act. Sought compensation for the loss, whereas the respondent were petitioning to have a restrictive interpretation of the word damage to property. They were saying damage to property only means physical damage, not damage to the intellectual property. I hope you have understood the full case. So this was very important for you to understand for your upcoming examination. So what is the significance of this particular judgment? It expands the legal protection of the minorities, legal protection of the works done by minorities, also the work done in the area of intellectual property. Okay, now in order for the marginalized society to grow, marginalized communities to grow, it is very important that the scholars of those community should come up and their works should be protected. So this judgment is another facet of right to equality in this country. In order to implement equal protection of law, which has been in important provision of Article 14 of the Constitution, this particular judgment has been a guiding light for that particular thing. So expansion of the legal protection, that is one of the most important significance, where the protection will be given to any intellectual property which is made by the SC/ST community, and it will be the state's responsibility to provide compensation if there is any kind of loss or damage to that property. Now, what is intellectual property? It something which originates from the mind. It can be inventions, it can be literary or the artistic work, it can be designs or symbols. And intellectual property rights, they are very important and strong in our country as well, because these are the basis for innovation in the country. If you want the country to grow, if you want the country to reach to its optimum level, if you want individuals to come up, intellectual property and their protection is very important, or else anybody can come up and stole somebody's property and show that property to be his, show that invention to be his, which is not the case. So meritocracy needs to be protected, it needs to be awarded, and that award cannot be given until you have stronger intellectual property rights, and that applies to the SC/ST marginalized communities as well. They give the exclusive right to the creators over their work and protected under Article 27 of the Universal Declaration of Human Rights. So there are few frameworks which are followed. If you see internationally, these are conventions which are a very important convention with the respect to the intellectual property. In India, we also follow the World Intellectual Property Organization. India is a signatory to it, and TRIPS agreement, trade related aspect of intellectual property rights under World Trade Organization, and the policy which India has made in 2016, which gives important provisions or important safeguards to the intellectual property in India. So it is a landmark judgment. As a conclusion, we can say that it ensures the intellectual property protection for all regardless of caste. This is a very important thing which has came out of that particular judgment. It strengthens India's knowledge economy, which is very important if you have to make Viksit Bharat. Viksit Bharat should also have the contribution of the marginalized community, and there is where the importance of protection of intellectual property by the marginalized community comes into question. Then it encourages innovation and intellectual contribution. So this was an important article to understand for your upcoming examination, and thank you very much for joining me. We will be coming up with next important topic in the next lecture. Till that time, be safe. Thank you. Bye bye and Jai Hind.